Now, at the time when the notice was given, he was there presiding. At the time when a motion was moved, he was still presiding. At the time when the leave was sought to be granted, he was presiding. A writ petition was filed that you could not have presided at the time when leave was granted to move the motion. Right? Leave was refused. So, the question then arose and the court said, look, under the Constitution and the rules of the Assembly, he is not required to vacate his chair when leave is sought. Because the resolution only comes up for consideration when a particular day is fixed for its consideration. Precisely what we've been arguing before your Lordship. That's the judgment. Just give it to my Lordship. Some words, have been glossed over, which I'd like you to invite my Lord's attention to. 181.1. It says, it starts with the expression, at any sitting of the Legislative Assembly. It's very important, those words. While any resolution for removal of the Speaker from his office is under consideration. So, it has to be a sitting in the Legislative Assembly, not outside, while the resolution is under consideration. So, it gives you the time, the point in time.
You have a point.
Yes.
Yes.
Not at the time when leave is granted, not any time earlier. While it is under consideration, the Speaker, or while any resolution for the removal of Deputy Speaker for his office is under consideration, the Deputy Speaker shall not, though he is present, preside, and the provisions of Clause 2 of Article 180 shall apply in relation to every such sitting. That's the only embargo. So, the Constitution gives you the point in time, that he cannot preside. Now, this relates to him. There is no conflict of interest between him and third members under the 10th schedule. There is no conflict of interest. So, you can't apply the principle of conflict of interest to a proceeding under the 10th schedule where he is dealing with third parties. So, the whole premise of the argument is untenable.
There are 2 points here.
Yes.
That is, while is one aspect, and other is that this talks only about himself. And
that's all my contention is. You can't make a constitutional assumption, because the whole argument has been on the premise that there's a constitutional assumption that he'll act mana fide. When Kyoto Holohon, just that paragraph of Kyoto, I'll give to your Lordships, says you can't attribute to the Speaker any such mana fide. That's why the provision of the 10th schedule was upheld. And just give your Lordship just the page. I marked it on the. Just that paragraph I'll give to your Lord.
You so easily vacillate from reposing such great confidence on the Speaker on the one hand. Within a split second, you would again, I'm saying.
I agree.
In a split second, we know how the speakers have worked.
That's true. But that's precise. That is why.
These two things which go from.
That is why the minority, according to me, was right. Because only you had to only strike down that part which gives Speaker the authority. The rest of the 10th schedule would be maintained. The problem is with the Speaker.
He would
135.
A noble judge, a noble chief justice is making a noble assumption about
Yes.
That's not how things have panned out.
Those are different times.
But the point is, you as a constitutional court cannot on the assumption proceed that he will act mala fide. That's the point. That's why your Lordship keep on asking me, what if he does this and what if he does that? That constitutional assumption you can't make. Otherwise, he should not be the authority which adjudicates.
But can we overlook the situations that have been thrown up after 92?
No, I'm not saying overlook it, I'm the last one to say overlook it. In fact, I'm the one to say he should not have that authority. But I'm saying as the law stands, So just note that I will not read it. 115, 118 and 119. And 119, it says, accordingly, the contention that vesting of adjudicated functions in the Speaker would by itself vitiate the provision of the ground of likelihood of political bias is unsound and is rejected.
Yes.
Anyway, I'm giving you guys your
Thank you.
I see the Chokdar as the very Lordships. In the event your Lordship is not sitting in a constitutional bench in the afternoon, then I can finish in 10-15 minutes.
What do you want to do?
Because
Then you can conclude.
I thought so, because
Yes. Yeah. Nice.
Your Lordship will pardon me.
Yes, sir.
Yes, deeply obliged. And I'm grateful to your Lordships for the time you've given.
Thank you, Mr. Sibal.
Well, let us get back to the discipline of the core issue arising. Refer or not refer? Should it be reference and why reference? That's the query my Lord put between. I think my Lord the Chief Justice put it. In fact, Justice Shah and Justice Narasimha also put it. Was Nabam Rebia the basis of their case? Was it the basis of the order? Was it the basis of the entire litigation? Now, Mr. Jethrani tried to address the issue directly today morning. And perhaps he has not been rightly advised. His clients have made repeated averments directly to the contrary. Every argument of my learned friend is belied by in writing pleading. My learned friend has showed one letter to your Lordships. Just note in sequence, the Lord should be astonished how much entirely relies on Nabam Rebia, which is why your Lordship will refer it, unless your Lordship wholesale agrees with Nabam Rebia, obviously. If your Lordship doesn't agree with Nabam Rebia, it has to be referred. Now, kindly note that. Just note the pages first to save time, then I'll show the pages. My learned friend with great respect has made an oral argument without being advised about his own client's pleadings, or at least his related client's pleadings. PDF 160, I'll give all the PDF first together, so Lordship will be able to follow it more easily. PDF 160, this is all in compilation CC1. That is not case law compilation, but the main CC1.
CC1.
Pleadings.
Convenience compilation.
Yes, CC, convenience compilation. The PDF pages seriatim are 160, 167, 174 and 193. 4 pages.
193.
Yes. So 160, 167, 170, 193.
174 or
174 you said.
Yes, I'm very sorry.
174 and 193.
That's right. So 160, 167, 174 and 193. And one more thing, Malis. They then have filed written submissions here opposing the reference in your Lordship's court. In that written submission, page 3, para 3, there are 5 things. Now, Malis, where is CC1? Now, Malis, remember, your Lordship is considering only 2 issues. A, are you agreeing with Nabam Rebia or not? That your Lordship has already heard of the merits first. These are the errors of Nabam Rebia, they are the problems, they are the consequences. The other is, Nabam Rebia is only a casual, marginal, possibly inconsequential basis of the other side's case. In which case, even if your Lordship disagrees, why should your Lordship refer it? Now, this is completely, I'm astonished. Now turn to 160. My Lord has got 160, there's a PDF page. The para I'm referring to is Romans 17. This is how we came on 24th, 25th, 27th, etc. of June.
What is this page 160 that you are reading out?
I am reading 160.
What document?
The actual petition.
Sorry?
Part of the writ petition.
It's the writ petition by which the whole thing was born. Whole thing started, and this is what we argued.
Writ petition filed by them.
On
which 27th order was passed.
On which, and that's the foundation, there's the main Shinde petition, if your Lordship may so call it, on which everything is founded. That's 160, I'm sorry. It's a short paragraph. 34 MLAs of Shiv Sena issued notice, including few independent MLAs, issued notice under Rule 11 of the Maharashtra Assembly, read with Article 179 of the Constitution to the Deputy Speaker, Mr. Zirwal, to move the motion for removal from the office of Deputy Speaker and requested him to refrain from discharging the functions from immediate effect. A true copy of the translated notice of 21 June, etc., for his removal is annexed. Now, there is one important point here. I did not say it until I showed the page. Along with this reliance on Rebia, which I will develop in a minute, is a major suppression. Major suppression. And both suppressio veri and seditio falsi, both aspects also. Your Lordship heard hardly 1 hour ago that nothing turns on this because this was rejected. Your Lordship heard it just now. Where is the rejection mentioned here? You have come to a court in a vacation seeking urgent interim relief involving the possible toppling of a government. Today, because it suits you, you argue that it was rejected. Now the whole para is here. Lordship will look behind and forward. There is no mention of rejection. It's completely suppressed. Now go on. Kindly proceed further. Now come to 174. So, there is a remarkable intersection of suppressio veri, seditio falsi, and reliance on rebia. It will just, when I complete, you will see the total picture. And it's true in constitutional adjudication, we can have very large, nice issues, but ultimately there should be some discipline of law. How you came to the court, what you relied on, today your Lordship is considering reference, not the merits. 174. Oh, sorry, 167. My apologies. I gave the wrong page.
That specifically refers to Navam rebia.
Yes. Now comes the ground, the first ground. No, see the whole construct, the basis on which you came, you entered the door with this basis, got an order, and today because Navam doesn't suit you, you have been disloyal to Navam and beholding it. The petitioner is filing the present writ petition on the following amongst other grounds which are taken in the alternative first ground. First, Deputy Speaker cannot disqualify any member under Schedule 10 during the pendency of his own removal resolution because this Honorable Court in Navam, so-and-so, 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 has held that the Speaker or the Deputy Speaker during the time of the pendency of a notice of resolution for removal cannot disqualify any member. The relevant paragraph reads as follows. Now we have harassed your Lordships enough.